Our next case is INRE AMJMNAC. Council, we expect anyone else to be here today?
No, I believe the other party is
Maybe it's
waiting.
gonna stop. I'm sorry for interrupting, but it's driving me crazy.
Sorry.
Each party will have 15 minutes to present their argument. Council, how long would you like to reserve for rebuttal?
5 minutes.
All right, the court will note the 5 minutes. You know, Medvick will be looking at that top button up there for you. When you get down to 5, that will be in your rebuttal time. If you keep talking, that's fine. I'll just take it off your rebuttal time. If you get done early, you'll still have the 5 minutes left for rebuttal time.
Thank you very much.
As you know, the lecture is being recorded. Please stay behind the podium so we can catch you visually. Please speak loud enough so we can hear you. And of course, we have children who've already referred to by initials. If you're referring to any other children or victims or anyone, please also refer to them by initials rather than their full names. With that, we read your brief and are ready to proceed whenever you are.
Thank you very much, and good afternoon, Your Honors. May it please the Court, I am Alan Medvick, and I'm here on behalf of the appellant, Father Derek Collins, in these matters. And we have raised one issue on appeal that the trial court erred in failing and to grant legal custody to my client of the minor children in these matters, and that it was the manifest weight of the evidence was in favor of my client receiving custody. The record shows clearly that my client had accomplished every case plan objective that he was given, that he had a bonded and healthy relationship with his children, that he was capable of caring for the children, that he was able to meet their basic needs, and that for a sustained period of time he had in fact been named as the supervisor for mother's visits in these cases. And yet despite that, and despite the statutory mandate that reunification with the parent be the first goal of public agency, the agency instead placed with maternal grandmother, and the caseworker in this case, Ms. Holt, indicated that she incongruously had not spoken to father about custody despite that mandate and the fact that he had been working the case plan and involved in his children's lives, because he had not outwardly stated to her that he wanted custody back. There's nothing in the record to indicate that my client was not capable of caring for these children, of taking care of them, and of keeping them safe. And there was nothing in the record that indicated that there was any issue with my client at all.
Well, I will certainly say, to start with, your client should be commended for doing everything he did and again, completing the case plan requirements, and we recognize that. But it seemed the trial court was concerned that because he still lived with mother and mother hadn't done no thing, that the children would be at risk if they were placed in the home. And also seemed to have a fear that, if I recall correctly, that your client may not have made sure the children were left alone with mother because they were living in the same house. So I think that was a concern that was raised. Did your client address that in any way, shape, or form, by testimony or otherwise, that I'll make sure the kids are never with mom and they'll be okay?
Was not really given that opportunity. What I would say is that he had done so through his action as a supervisor. There is no indication that at any point in the time when he was named as a supervisor for those visits, that he allowed mother to stay along with those children, that he allowed mother to be around the children when she was under the influence of any drugs or alcohol. There's also no, while it is clear that mother did not, and undisputable that she had only recently engaged in any substance abuse counseling and had been resistant to that throughout the case. There's also no indication that she had been, and she wasn't dropping. I'm not going to pretend that she was compliant with the case plan. She's not my client. And yes, she is the issue here. But there's no indication that that substance abuse remained an issue, that she remained actively using, or that there was any instance. No one could point to any time, including many expanded visits and overnight visits, and these supervised visits were going on, and there is no indication of mother's continued substance abuse causing any harm to these children.
And counsel, if I can interrupt for a second, that was exactly what I was gonna ask you about. What were the conditions for the visitation? Because evidently they went from, just visitation to overnight, then all the way up to a week. Was
And-
that father could never leave the children alone with mother? Was that a
And-
condition of visitation?
I believe that is a condition that father was the supervisor.
Well, what I'm getting at though is, in the 7-day period, father surely would have had to work unless he took vacation.
And what I would tell you is that there's nothing in the record to indicate how that was,
Okay.
how that went, how that happened, okay?
You
My
believe the record
recollection-
indicated that father was supposed to supervise mother's visits, what would
Yes.
happen if there was visits for them for a week?
And
The
there's.
record doesn't show.
The record does not show that mother was left alone with those children. I can't speak to that, but there is no evidence in the record that he did not comply with those supervision requirements. That's what I can tell you, is that grandmother doesn't have any indication that she thought mother was left alone with the children. Ms. Holt doesn't, the CASA does not. There's no one in that record saying he won't do what he's told. The only thing is Ms. Holt and the CASA's opinion that somehow once he is given full custody, despite a lack of evidence to the contrary, that he wouldn't abide by that supervision requirement, that he wouldn't be able to take care of those children, that he would somehow immediately be rolled over by mother and just let the children run.
And I recall, he did not testify in this case to say, yes, indeed, I would do those things.
Neither
Or,
parent,
didn't testify one way or the other to say yea or nay.
neither parent testified. That would indicate that's true. But even with the evidences the agency put on, there is nothing to indicate that father was not capable of taking care of these children. And in a least restrictive setting, there could have been orders, and those were requested, that those be court orders, that those children be supervised. And again, some of this is on the agency. They didn't have these discussions with father, even though it was clear that he wanted custody. There's nothing in the record, in fact, when asked, Ms. Holt said that she'd never had that conversation about what would it look like if you were faced with how would you handle this situation. Ms. Holt hadn't had those conversations. Ms. Holt hadn't had a conversation about if it was the kids or mom, what would you do? That's not where we were at this point. Father going along doing his case plan, meeting all of his objectives, and then is told, we're not moving for custody for you. So I think that there's a manifest injustice, that there's a person who could have taken care of these children, who could have and wanted to, and it demonstrated that he was capable of doing it, and in the absence of any evidence outside what is essentially lay opinion and conjecture on the part of the caseworker, that he would not be able to do so. And so, I know it's a one-issue brief, I don't have as much to say as I usually do. I apologize. So I'll defer and save the balance of my time.
I think you have 5 minutes left for rebuttal.
May it please the court, Helen DiMartino, on behalf of the appellee, Summit County Children's Services, we are asking that this court affirm the trial court's decision awarding legal custody of these 3 children to their maternal grandmother, because that decision is supported by the weight of the evidence. This case started because of allegations regarding lack of supervision as well as substance abuse by both parents. There was also indications of domestic violence. This case, the adjudication decision was appealed and affirmed by this court, I believe in April 2023, at which time the court looked at the allegations, the ongoing issues with drug abuse between the parents, the domestic violence, and the fact that mother and fathers remained in a romantic relationship and resided together even when there was a temporary protection order in place. So there is more than just speculation and conjecture in the record as far as would father follow an order if there had been one. As far as visitation,
And that's what I was gonna get at.
the
talk
record
about that.
does not have exact numbers of visitations in there. There's just the testimony, fluid comments about what it was. So you're not gonna find, there were 10 supervised visits that lasted a certain number of days.
Does the record reflect though that they had extended visitation up to a week.
The record reflects that, I think it's on page 70 to 72, and then again on page 100, that the children were having 2 days visitation consistently. There were also, quote, several overnights during the time period from the, once summer ended and school started. When they did have overnight visits, they were to be supervised by father, who, yes, completed his case plan, that is very commendable. But mother was residing in the home, which was the big issue, is mother, and there is evidence she had ongoing substance abuse issues because she tested positive in, I believe it was January 26th of 2023, did not ever get the substance abuse assessment until July of 23, and the hearing was in November. So she had only had a couple of sessions. So that substance abuse is an ongoing issue. So they never did, she never got to unsupervised visitations. Father was able to do the supervised visits. They were never for more than 2 nights at a time. The one time that they exceeded that, it was like 4 or 5 days, the record indicates. They shouldn't have done that, they did that for whatever reason, lack of communication, whatever it was. But in that
Who should
time,
have done that?
mother and father should not have been able to have the
But
children.
CSB allowed it.
The child was with the maternal grandmother, so
Okay.
she would have allowed that.
I was gonna say, there's no court order to say they could have 4 or 5 day visits. There
Correct.
was an order that was 2 days, and at some point, as I recall in this case, as you indicated, grandmother acted outside those rules and permitted. For whatever reason, I don't know, I don't recall the reason, she had to let them have them for a few extra days.
Correct.
And
And
the
that,
agency at that point said, hey, that's not supposed to happen, don't.
correct, and at that particular time, when they did have the children for more than the 2 overnights, the children missed their dental appointments. So there is evidence that the time that dad has the children and is able to supervise mother, it is for a short period of time. Unfortunately, there is an ongoing substance abuse issue on mother's behalf, and she is not seeking treatment. There's no dispute that from that first drop, July 13th, 2021, she refused to submit to urine drops of drug testing until that test that happened again January of 2023. And courts have consistently found that when you refuse to drop, those are considered as positive. And then when she does drop again, finally in 2023, that test is positive. So based on the long history of mother and father residing together and father not always following court orders, including to honor a temporary protection order that was issued with this domestic violence issue that is part of the ongoing case regarding these 3 children, there is a basis to believe that father may not follow a court order if it had been in place with regard to never leaving mother alone,
Well,
which is
and
not
I guess
something
that's
that.
what concerns me.
Mhm.
If father was never under a court order to not leave the kids unsupervised with mom, how can we then say father, violated anything or the CSB demonstrated that best interest of the kids would be legal custody of grandma?
Well, he was, at the time, he was under protection order, that's different, but
Yeah, that's
there was an order for him, he could have unsupervised visits, but mother's order was supervised, and he agreed that he would supervise those visits. So he technically is under that order and agreement to not leave the children with mother.
And was there evidence presented he did in fact leave the kids unsupervised with mom?
That is not in the record, just that when it was a longer period of time that they missed their dental
But
appointment.
there's no reason why it's.
No, that's correct.
Maybe it was not communicated to them or whatever.
Correct, that is correct. But it's also important to remember that we're looking at legal custody, which is a best interest test, so we're looking at the best interest factor, the 2151, 414D, and if any of the E factors apply, and then 310904. So we're looking at it from the perspective of what is in the children's best interest, and those factors include their relationship with the maternal grandmother who's had custody of them for more than 2 years, who they're bonded to, who the 2 older children want to reside with. The youngest child is 2 years old, I guess 3 years old actually at this time, is not able to express where they wish to reside. The guardian ad litem indicated that it is in the children's best interest to be in the legal custody of the maternal grandmother. Maternal grandmother does assist with the visitations, even though the relationship is strained because mother apparently, blames her mother for all these things that are swirling around with regard to children's services, which goes to the heart of not addressing and remedying the situation that brought the children into the care. They do deserve permanency. If mother does not acknowledge, address, remedy her substance abuse issue, the children will not have permanency because they will have to be removed again if they were in the custody of mother and father. So when you look at all of the best interest factors, while father certainly has done a wonderful job of working his case plan, he is still residing with mother, and mother is still not doing the things that have caused the children to have been brought into the care of the agency, which include lack of supervision and substance abuse issues. And based on that framework of best interest of the children with regard to a legal custody motion, the agency would argue that this decision is supported by the manifest weight of the evidence and should be affirmed. And if at some point down the road, mother is able to remedy the situation that brought the children into care, she can always petition at that time for a change of custody. She still has residual rights. This is not a permanent custody determination. There's nothing further. I'll rest on the brief.
See nothing, thank you.
Quickly addressing a few things said by the appellee. First, we're talking about things outside the record. I believe that there was an allegation of violating temporary protection order and charge filed in Stowe Municipal Court that was dismissed. So I think that the claim that could be used as evidence, even though that would have occurred at the start of the case in 2021, well before my client had gone through the anger management program and completed whatever case plan objectives were in place. I also do not think that you would find, even in the public record, violating protection order charge against my client.
So you're saying that's not in the record then?
I do not believe that is in the record. Grandmother is not party to this case, and I know that we are talking about the best interest factors and the relationship between the various parties and the various entities, but the first and foremost parties to this case are the parents, including my client, the father, who is in the best position to take care of his children, and I think that that's a constitutional right that the grandmother does not have here. She's commended for having been the custodian throughout this case, but ultimately, father is the parent to this case, and when we're talking about those relationships and those parenting factors, ultimately, returning custody of the father has to be, and is stated in statute, that that's the primary goal.
But isn't that all taken into in regard to the best interest of the children?
Yes, absolutely.
And even the two older children here want to be with grandma.
And again, we have a strained relationship here, and that, I think you'll find that the record indicates, while grandmother testified that she was, had at times blocked both parties from communicating with her or with the children, based on her feelings of disrespect. I think Ms. Holt indicates that this is a two-way street, that these communication breakdowns are at the worst in equipoise, and those relationships are going to be strained, I would argue, that being, and so I don't know what, and we weren't in a position at any point to work on counseling between the father and his children, and how that relationship might look later on. We're left at the end of the case for the CASA to ask what's going on and where they want to be. And that is one factor, and I don't dispute that the older children have said that they want to stay with grandmother and maintain that relationship with their parents in terms of long-term visits. Obviously, with the children, those are things that I think what I'm hearing is that they want to maintain a relationship with all three entities, and how that would look, I think, could be managed quite literally by the adults in the room. So I think we're talking about a father who was involved in this case for a full 2 years. This case was extended in 2 different 6-month incidents, while father, and based largely on father's ability to complete his case plan objectives, and to, at the end of the day, say, well, yeah, but you're still with mom, when that had not been stated clearly. And as indicated, the extended visit was a decision by all parties, including the grandmother. as a custodian to let them stay, and then it was the CASA and the caseworker who came in and said, that's not really what we're talking about right now in terms of expanded visitation. So I don't think there was anything nefarious there. I think that was miscommunication by all parties involved. And there was questions about, throughout this, about whether my client was getting notice of the medical appointments, including the dental issue indicated by Heaven. And I would ask, at this point, I would rest on my brief, and I think I've been clear that I think there's a problem with the manifest weight, and I'd ask to be reversed.
Can I
Yes,
ask
sure.
you, you mentioned that you don't think there's anything in the record that, about the violation of a protective order, is that correct?
I am unclear, it's not something I was, but I think what you will find is there was, it may be indicated in the complaint that there was that charge, okay, but ultimately that charge was dismissed.
But there was something in the record, right, about the children witnessing the domestic violence?
And I believe you may find in the, that would be in the complaint, the principal out of, I'm not sure if you will find that in the record, because if you review the complaint, and I handled the appeal on the adjudication here as well, the complaint was based on the children being left alone in the home for a period of time. Father did have a pending domestic violence charge at that time. I think that's where the TO came from as well. And there may be indications in the complaint that, and I don't know if the transcript from that adjudication will be here, because obviously it was a contested adjudication.
I believe I'll look, but I think was there something that suggested that the children are still have memories of?
And
even
I
though-
believe that one of the things that the CASA will say is that the reason why they want to stay with their grandmother is based on behaviors they observed in the home. That is in the record, in the transcript of this hearing. You will see.
Thank you.
Yeah.
Thank you, Counsel, your time is up, you may
Thank you.
conclude if you like.
I would ask that you reverse this decision and place the children in my client's custody.
Thank you.
Thank you.
And on behalf of the court, thank you both for your presentation this morning. The court will take the matter of advisement and look for decision in due course. With that decision, please email you by the court and also be available in the